Hey, what's going on, guys? Happy New Year to everyone. Hopefully everyone's doing well. They had a great start to 2024. As you see, I'm back to it, back to walking. Get some more exercise in. It's been about, say, almost a full month that I'm back to work as a U.S. DoD contractor for the Air Force. So, yeah, happy to be back to work. Happy to be amongst other veterans, contractors, military personnel. So it's good. But, yeah, let's see what 2024 will hold for me, my family, and for the rest of us. But I wanted to make this video, or at least start this video off as an intro to talk about a video in regards to my experience, my experience with dealing with air property in my family. It's kind of windy here, so hopefully you can hear me. I mean, this is a new camera for me. I had for a few months now that haven't quite mastered it and all the options there for having a Bluetooth mic or a microphone. But anyways, so since I've been involved with this air property dispute, who are heirs and who's not heirs, the individuals that sued my family back in 2011, 2015, and when I got involved to acquire a title in 2017, 2020, the order was signed in 2020, March 31st, 2020 to be exact, and there were still disputes of who were heirs and who was not heirs. And individuals claimed to be a descendant of Washington James, who was one of the original owners of the property, which is my grandfather's grandfather. So essentially he'd be my second great grandfather, my mother's first great grandfather. Anyways, so they claim to be descendant of Washington James, saying that one of his children was Joshua Samuels, who was the firstborn child of his mistress, because he was married, of course, and had other children, or had a child with his wife. Anyway, so now the individuals that claimed that Joshua Samuels was one of his children are now backtracking, are recanting their statement and saying now that they are descendants of Toby Cox, which is now my grandmother's, right now, my grandmother's second great-grandfather, or great-grandfather, which is my third great-grandfather. So Papa Sim, which is her grandfather, that'll be his father, Toby Cox. So now I'm saying that they're a descendant of Toby Cox, which is not true. And they're doing so by claiming that their mother was raised by one of Toby Cox's children, which is a sibling to Papa Sim, Papa Simon Cox. Now, for those that understand air property laws, air property rules, probate, and if you don't, raised children are not considered to be heirs because they are not legally an heir to those who own the property, or legal heirs to a person, right? Unless they are legally adopted. But to be an heir, you have to either be born from a woman, right? So by birth, or by blood, meaning DNA from a man. So you know who your father is, you know who your mother is, because you're born from that woman. Julie Cox, according to my family history, didn't have any children. Although she was married, she didn't have any children. And to raise a child does not make that child her heir unless she legally adopted that child. And this is state law. This ain't me just making stuff up. So, and for these people to first say that they were descendants of Washington James, using the name James. Actually, let me backtrack. Before that, in 2011, from 2011 to 2015, they claimed that they were descendants or related to Tim and Laura Samuels, who were on the original deed to the property. And I'm really getting deep into it. I know it's just the intro, but I want to get some backstory before I really get into it. But that's what they said. And then from 2017 to 2020, oh no, they are a descendant of Washington James. And now in 2023, they're saying that they are descendants of Toby Cox. So essentially, they're just fabricating their story. They're just making stuff up. They're just throwing names out there. It really shows that they don't know their own history, or it goes to show that they'll say anything and do anything to claim rights to this property, to be identified as heirs to property, to have an investor's interest in the property. But yet, let's go back in time. So if they're not considered to be heirs or having investor's interest in the property, meaning that they should never have been a part of the lawsuit in the first place to sue my family back in 2011, 2015. But I'll leave it at that. I know it's kind of a long intro, long explanation, and I'm gonna get back into it when I get to my house, when I finish my walk. So stay tuned. Okay, so I'm back in my office, as you can see, finished my walk. So let's just get right back into it. So I did talk about the backstory of basically what is heirs property and the whole 9 yards, my experience of dealing with heir property, and essentially what's the purpose of this video, right? So some of the defendants are now claiming to be a descendant of my third great-grandfather, Toby Cox. Now, Washington James is my second great-grandfather, and Toby Cox being my third great-grandfather on my grandfather's side and my grandmother's side. So these two men essentially were two of the original owners of the property, along with some of their alleged to be brothers and sisters and everybody else, for that matter. But again, the defendants are claiming to be descendants of Toby Cox, that one of his children is their mother, or is their grandmother. But in 2017, when I brought this case acquired title to the court, and we had our hearing in November 2018, while on the stand, one of the defendants was giving testimony when she was asked by her then attorney, of how she claimed to be an heir to property. And she said on her father's side that her father was the grandson to Washington James, and again Joshua Samuels was the son, one of the children. Therefore, her father was the son of Joshua Samuel, so essentially the grandson to Washington James. And then on her mother's side, she said that, well, this part comes sketchy. Again, I have the transcript to prove it, but I'm not going to show it here. But I'm just explaining to you, the viewer, as to what transpired during that hearing. And so she said this is where it gets sketchy, because her mother's mother died when she was 2 years old. So essentially, when her mother was 2 years old, her mother died. And so she was raised by Julia Cox, which is one of the children of Toby Cox, who was one of the siblings of Papa Sim, my grandmother's grandfather, my third great-grandfather, my second great-grandfather, Simon Cox, or they call him Papa Sim. So Julia Cox raised her mother as her own. Now, again, so that leads me to what I talked about. Raised children are not considered to be heirs, because the state law is that it has to be legally adopted, or children can be left in a will. Anybody can be left in the will. They'll be considered to be the heir, or they'll leave them their interest in the property. But raised children are not heirs. Again, these are not my words. It's not something I made up, and I will take the time now to show you where I get this information from. So let me set this up, and then once I have it set up, we'll continue the conversation. Okay, so what you're seeing now is the Center for Heirs Property Preservation website, and you know, I'll leave the link in the description below, or leave the link to this website in the description below of this video. But when you come to this website, this page, go to the, you know, protect your land or put your land to work section here at the top, and you can scroll down to the bottom. It talks about the body of work, what they do, the buckets of work there, prevention, resolution, sustainable land use, such and such, etc. Right? Yada yada yada. And then the service areas show all that. But you want to go down to the FAQs, the facts answering questions, right? And you see that I already got it open to where, you know, it says who is an heir. An heir is anyone related by blood to the person whose name is on the deed to the property, and those persons relate to him or her by law, right, or birth, including a spouse by legal marriage, a spouse by common law marriage, provided they have lived together and presented themselves openly to the community public as being husband and wife, a spouse who's separated but not legally divorced, children by birth. I already mentioned that, right? So children born from a woman, children by legal adoption, not raised children, outside children. Outside children mean, you know, they're born outside the marriage, right? So they're, you know, the husband had a mistress, such as in our case, we had our Martha Samuel being my second grandfather, excuse me, mistress, because he was already married. So therefore, any children that he had with his mistress is outside the marriage. That's what that means. In some cases, call it illegitimate children. Children are separated but not divorced spouse. There's no such thing as common law divorce. All right, so there it is. So either by birth, by blood, legal adoption. So your outside children, your spouse, people that have common law relationships. There it is. Right. And then scroll down a little bit further. It just says who is not an heir. Again, talk about raised children are not considered heirs, but it says right here, who is not an heir? Legally divorced spouses, raised children, not legally adopted, and any non-family members are not heirs. Again, these are not my words. This is from Center for Heirs Property. And since the Center for Heirs Property is licensed to operate within the state of South Carolina, granted, not all counties, because I think it's like 40-something counties, but right now they have 25 counties they're operating in, to include one of the counties being where the heir property, my family's heir property, is located. So they're licensed to operate here in South Carolina. So you figure that this is a good source of information, that they even have attorneys on their staff that are licensed to practice in South Carolina. Again, this is a non-profit organization, so they're not doing this for profit. They get their where they make their money from is from, you know, the number of people they service. So they provide service to the public. You know, grants, would be state money, federal money, donations, whatever case may be, sponsorships. That's where they generate their money from. They necessarily don't generate the money from the clients, the customers, you know, people that have heirs property, unless it requires something extensive. Then they might it might come at a cost. But generally, as a nonprofit organization, there's no cost to the public, or a small cost, that is. Okay, so there is a nutshell. I mean, this is a good source of information, and again, them having staff, having lawyers on staff, has to be a legitimate source of information. We're talking about people who are not, who are heirs and who are not heirs, especially when it comes to raised children. Again, I mean, it's unfortunate that the individuals that I'm suing, some of them anyway, you know, they had opportunity. They had opportunity to provide their family tree when they first sued my family in 2011. And again in 2017 when I named them in the complaint to acquire a title to the property. They had opportunity to provide not only their testimony, the evidence to back it up, birth certificates, death certificates, marriage licenses, obituaries, you name it, census report, and now that is come to the forefront and it's still an issue, they're getting a third chance, right? A third chance at proving that they're heirs to property, but yet they're just using my family's name, and being of the association that they were raised by, a member of our family, kin to us, right? As she would put it during her testimony when she's on the stand, that Judy Cox is akin to my grandmother. These are her words now. And you saw where it said, family members, non-family members are not heirs. Right? So kin, we could be cousins all day. We could be kins. We can be family members, but if you're not a descendant of one of the original owners, you're not an heir. Point blank in the story. Doesn't matter if you were raised by someone or you live with someone. Doesn't matter. And they're going as far as to say that me and my mother had never lived on the property. That's not true. And even if it was true, it still does not take away the fact that we are heirs to property, that we can trace our lineage back to original owners. They're going to have to prove that. They're going to have to prove their claims that me and my mother have not lived on the property. But there is law, right? Or there's no law that says that a person has have to been born on property, have lived on property, have worked on this property to be an owner of the property. Like I said before in my other videos, in that case, we would never own property. All the wealthy people in the world who own thousands and hundreds of thousands of acres of land, who never originally owned it, how are they owning it now? How can they say that that's their property if they never owned it? How is that people across America might live in California but own property in New York? Or vice versa. Live in Florida but own property in California, or Nevada, or New York, or New Hampshire, Connecticut, Rhode Island, South Carolina, wherever. It's not the case. It's just not the case. And those individuals who may have lived on property at some point in time, or are living on property, or born on a property, still do not have greater rights or interests to the property versus those who have never lived on a property. I was not born here in South Carolina. I was not born on the property. My mother was. Her siblings were. Her parents were born and raised on the property. Right? But still, that does not take away the fact that they would have greater rights or interests in the property than somebody else. That's not how it works. That's not how it works. Again, this is not my rules and laws. It's what's in the state of South Carolina. So there's nothing in writing to say that. There's nothing in writing to take that away from people who never lived in the property. Because you can have some of the original owners' property, their grandchildren who are alive today and their great-grandchildren. So the grandchildren's grandchildren or grandchildren's children, they have an interest. They were not born on the property. They might live in Virginia, New York, Connecticut, Georgia, Florida, wherever. Never set foot on this property, but they still have rights to the property by way of their parents. By way of their parents. So again, that is not the truth. That's not the truth. And I have some documents to show you. I'll put on the screen. I can pull up. One being, again, this is for heirs property. This is from the Census for Heirs property. Their pamphlets. And I'll show you here. This is where I get it from. Those of you that are interested, if you've been to the seminars or workshops, it's right here. It's their pamphlet that they'll hand out. A lot of good information in here, but I'm going to show you one page of it. This is page 9 here, and it says, at the top it says, creating your family tree, who's an heir? And you go to the middle of the page, a paragraph where it says, who's a legal heir? The second paragraph, raised children who were never legally adopted do not inherit unless the deceased left them in an interest in the property in a written will. Simply using the deceased's last name does not entitle you to inherit as an heir to the estate. Under current South Carolina law, children born out of wedlock, illegitimate, are considered legal heirs and are able to inherit from a mother or father who died without leaving a will. If you're claiming interest in the land as an illegitimate child, you may be required to prove paternity to establish your claim. There it is. Again, one, they're saying that they were raised by Julia Cox, right? So they're not an heir. And two, using the last name of, say, James or Cox does not make them an heir. So there, that's 2 strikes against them already. Really, they had 3 strikes against them because they claimed to be an heir of Tim and Laura Samuels back in 2011, from 2011 to 2015, but now they're denouncing that. Now they're saying that they didn't say that. That's not true. They claimed that, no, I said I was heir to Martha Samuels. So really, they have more than 3 strikes against them, right? I mean, like I said, this is their 3rd opportunity to prove that they're heirs to the property, and not doing so well. Not doing so well. I mean, they even had an attorney. They had the attorney that represented them in 2011, from 2011 to 2015, was the same attorney that represented them in 2017 to 2020. But this go around, they don't have an attorney to represent themselves, and for them to walk back what they said, to try to clean up what they said, you know, it's not doing them any favors, right? Really, in my opinion, again, I'm not an attorney, but you know, some of the information I discovered, you know, is all online. So I don't need to be an attorney to, you know, discover the truth, you know, to know the law, to know the rules. But in my opinion, they're just digging themselves a greater hole, into a bigger hole. But nonetheless, it is what it is. Now, they claim that, you know, me and my mother never lived on a property. You know, that's a myth in itself. And I covered this before. I think I talked about this before. You know, here is another snapshot of this booklet here, right? I'll show you on page 6 of it. It says common myths and reality about heirs property, and go to the second myth. It says physically living on land gives an heirs greater rights to use and ownership of the land than those who do not live on it. The reality, no, heirs who do not live on the land or help to maintain a property have the same rights as heirs who live on the land. There it is again. So they don't have to prove their claims against me and my mother. They don't have to prove that, one, me and my mother, me and my mother never lived on a property, which is, again, not true. And I'll gladly be able to testify that in court, and so will my mother, and I'll present the evidence in court. You know, just like they're going to have to do the same. But for them to now say that they are descendants of Julia Cox, that their mother is a daughter of Julia Cox, is false. And granted, they're going to, you know, back in 2020, and maybe I cover this in another video. I don't want to do it now, but show the evidence of this. I won't show the evidence, but in 2020, I went back through FamilySearch.org and researched my my family lineage, and discovered that there was a census report. There was a census report in 1940 where it shows Julia Cox having a daughter, but the daughter's last name wasn't Cox. It wasn't Hunter, which was her married name. It was Howard. And this information lines up to what defendant gave during her 2018, during her testimony in 2018, when she was being questioned by her then attorney, on the stand, as to, she said that my mother's name was this, and her father's name was this. You know, so it lines up. I mean, those are her words, and I believe, you know, I can't wait to present that to the court, to show to the court that, hey, here it is, Judge, Your Honor. Here's what she said in 2018. You know, but that's that in a nutshell. I mean, I just want to point out that for anybody who's going through this, for anybody, whether it be here in South Carolina, North Carolina, Georgia, here in the South, dealing with family and heirs property, if there's individuals claiming to be heirs of property, you know, if they say that, well, I was raised by so-and-so or so-and-so, or I've been living in the land all these years, that does not give them ownership of the property. does not give them ownership, especially when it comes to defining who our heirs are. Like, the definition is a definition. The legal definition is a legal definition, because whether it is you go to the court to quiet a title, or you go to the court to petition for the court to determine who the heirs are, not to quiet a title, but you're asking the court to determine who the heirs are, like part of the probate process, right? Because if it's 10 years or less, you can do that. You can go to the court and says, hey, my family member's been dead for less than 10 years. I want to probate his estate, his or her estate. So I'm going to petition to the court to, determine who the heirs are. Past 10 years, I guess you have to quiet a title, because now it becomes state property. It becomes an estate. So therefore, you gotta have the court to quiet a title to the property, right? So there's several legal actions, steps that need to happen depending on the time frame, how things work. So again, if you have individuals, whether they live on a property or not, if they come out of the woodwork to saying that they are an heir to somebody, they don't have to prove it. Raised children are not heirs. Divorced spouses are not heirs, and kin are not heirs. Kinfolk are not heirs, right? So I can have a cousin of mine, say on my father's side, that's my kin, is not an heir. Is not an heir to my father. Is not an heir to my mother. Not an heir. I'm their heir. Me and my sister are their heir, right? Just like a cousin that's on my mother's side, say my mother's niece or nephew, still not my mother's heir. The same applies to Washington James and Toby Cox. His children, who have a half brother and sister, right? Martha Samuel's firstborn son, Joshua Samuels, he is not an heir to Washington James, so therefore he does not have interest rights to the property. Even if his mother did have his Washington James' children, still not an heir, because they were not married. They were not legally married, and even if they're not legally married, her name is not on the deed to the property. Neither is her son's name to the deed to the property. And they can't claim ownership by way of his uncle and aunt, Tim and Laura Samuels, whose name was on the original deed to property. So again, kinfolk are not heirs. Nieces and nephews are not heirs. Cousins are not heirs unless their parents or grandparents or somebody they can trace their lineage back to is on the original deed to the property. That's the only way. So that's it in a nutshell. Hopefully I answered the question and explained it pretty well. That, yeah, raised children are not heirs. So it's just a matter of time before this is presented to the court and it's just cleared up that defendants are using my family's last name, my family's name, whether it be Washington James, Toby Cox, whoever, to claim an interest in a property. But when they sued my family, they did it on false pretenses. That should never happen to sue my family. It should never even go into court, based on what I'm discovering now. Based on what my family should have, either they knew already or they should have known. But let this be a lesson to everybody that may be going through this. Because again, there's videos out there that showcase this problem set, this phenomenon known as heirs property. It's been explained in several videos. It's been happening for, I don't know, last 20 years or so. And me, I'm talked about, I have like, over 70 videos, almost 90 videos expressing my experience and my viewpoints on heirs property and dealing with family and what are the rules and laws to this. So, I'm just trying to educate the people, you the viewer, whoever's going through this. If Miss Josephine Wright, the elderly lady that's fighting to preserve particular property over there in near Charleston or Hilton Head, South Carolina, she's fortunate that she's surrounded by family, and family is going to protect her and help her do the right thing, help clear up this legal issue. But others are not so fortunate. If one person within the family can sell his or her share of interest, no matter how big or small it is, to an outsider, and that one person now becomes part of the family and wants to buy up other shares or wants to force a sell, how are the heirs going to protect their property? Right? So imagine this one person is the person that I'm taking to court that's claiming an interest in a property. So if she or him is allowed to be an heir, what will happen to the property? Now that person can bring in other people who are not heirs and take over management of the property. And that's essentially what they did. Essentially what they did. And there's documentation to prove it, that they were claiming that they were individually and collectively doing business as the heir property committee, board, whatever, without any kind of paperwork. And he got on the stand and testified saying that, well, prior to this case, I was never part of the board. Then how are you suing members of our family who are heirs? So how are you suing people who are heirs, but yet you've never been part of a committee or board? But yet they signed affidavits saying that they were individually and collectively doing business as such. So again, it's all here in black and white. I don't have to make this stuff up, and my family and the defendants and everybody other mother can be mad at me because I'm bringing forth this to court. I'm bringing everything to light. Then so be that. I'll be the bad guy, right? Because if it's not me, who's going to be? The county, a land developer, a real estate agent, an investor, somebody who's been trespassing on the property that wants to claim squatters' rights. What are we going to do to protect the property, to fight this in court? But that's it in a nutshell. Like I've talked long enough. But again, the topic of the video is raised children not heirs to property, and I think I've shown the evidence, I've shown the information, I've shown the truth, and I explained this, to the best of my ability. So give this video a like, share this video, leave a comment, and I'll catch you in another video. Take care. Peace.